This is Law Bytes, a podcast with Michael Geist.
For us to prosper and benefit from this new digital landscape, we need to ensure that Canadians have confidence that their data is safe, that their privacy is being respected, and that companies are deploying new technologies responsibly. The bill I am introducing today will do just that for Canadians.
It has taken many months, but Bill C-27, the government's long overdue effort at privacy reform, is finally headed to committee for review. Philippe Dufresne, Privacy Commissioner of Canada, has been patiently waiting for this moment, armed with a comprehensive review of the bill and a wide range of recommendations for amendments that include a more explicit framing of privacy as a fundamental right. Dufresne was appointed as Canada's Privacy Commissioner nearly 1 year ago, and in the months since has made numerous committee appearances, issued high-profile findings involving companies such as Home Depot, battled internet companies in the courts, and worked on the privacy implications of new technologies such as artificial intelligence. He joins me on the podcast to reflect back on his first year in the position and to outline his proposals to strengthen Canada's best shot at a modernized privacy law. Commissioner Dufresne, thanks so much for joining me on the podcast.
It's a pleasure.
Yeah, I'm really glad that you've taken the time to join. There's, of course, so much to talk about. And before getting to some of the substance, we certainly have to talk about some of the privacy reforms in particular. We're about a month away as we record this from your first anniversary of your appointment as commissioner. And I thought we might start with a bit of a reflection. Other than the fact that time flies, it's hard to believe it's gone so quickly. What surprised you about the position, and what would you consider some of your major accomplishments in year one?
Thank you so much. Great starting question. So I think I had a good sense of what the role was going to be, but what surprised me was really the scope and the frequency of all of the privacy issues that are happening and that are impacting all of us on a day-to-day basis. I was speaking to colleagues from my former human rights world, where we would see headline issues about human rights matters maybe once a month or once a week, and on privacy, frankly, it's almost once a day. And so it really has confirmed what I knew, which was that privacy touches all of us. Not just those who are interested or knowledgeable about technology, and it touches all age groups, and it touches multifaceted areas of our lives. And so that's why it's so important that we get it right. In terms of the first year of my mandate, you're quite right. The time has flown by very quickly, and I'm very proud of having been able to join the amazing team at the OPC and to really get to know the incredible and engaged privacy community in Canada and internationally. So I have made it a priority to meet stakeholders, to meet colleagues, to meet academics, experts, privacy champions, and I've been able to do so here and internationally. There's been a number of international engagement, whether it was the G7 in Bonn of last year, and looking forward to the next upcoming one in Tokyo in a couple of weeks, the APA meeting in Singapore, the Reboot meeting in Vancouver, Legal L'Égalité in Montreal, IAPP Washington, Privacy Symposium in Venice, and I'm going to IAPP Toronto in the next few days. And so the community is engaged, it's knowledgeable, and it's frankly a source of inspiration and engagement and ideas for me. There's been a lot of activity in terms of parliamentary advice. I was called to the ethics committee very early on in the year to give views about the RCMP's use of on-device investigative tools, and to give my recommendation to ensure that privacy impact assessments be done and be legally required under the Privacy Act. I appeared in front of the Senate committee studying Bill C-11, not the privacy Bill C-11, but the broadcasting C-11, to talk about the privacy impacts of this legislation with respect to algorithms and promoting certain contents for viewers, and making sure that we had privacy as an objective of broadcasting policy. recently appeared again in the Senate committee in terms of Bill C-47 on the political parties and the extent to which they ought to be regulated by privacy law. We've prepared, of course, our C-27 submission, which I was expecting to have presented to committee by now, but certainly we were working very, very much all of last summer and early in my mandate, getting this ready for what we thought would have been an appearance last fall, but very happy that it is now public and looking forward to appear in front of the committee. There have been key investigations. I was very proud to release an investigation, our Home Depot matter, to clarify some of the issues there in terms of consent, in terms of reasonable expectations of Canadians when they're being offered a choice like an electronic receipt or a paper receipt. We're continuing to work on pandemic investigations. We issued our annual report. We've launched two major timely, important investigations with respect to TikTok, ChatGPT. We've had litigation in front of the courts with respect to Google and Facebook. And lastly, we've also had to deal, like everyone else, with the end phase of the pandemic and the solidifying of the hybrid workplace, a public service strike. And so really getting the office in a good position to transition to this and to keep the OPC as an amazing place in terms of providing key results for Canadians, but also a good workplace, healthy and safe. And so those are some of the things that I'm very proud of having accomplished in the first year.
Okay, that's a long list. It's a lot of frequent flyer miles, and also a lot of topics. And I want to drill down on several of those. Let's focus on C-27. And you're right; it's taken a long time even to get to this point. And I think there's been a fair amount of frustration with how long it has taken, even just to get this bill to committee. Now your recommendation focused on three primary areas, and I want to focus on all of them briefly. Privacy is a fundamental right, privacy in support of the public interest, and Canada's competitiveness in privacy as an accelerator of public trust. Now, you talked about an engaged privacy community. I think that's absolutely true, and we've seen that now over decades of privacy reform. Very often, we find different perspectives coming to the fore, and some might even take a look at some of those things, talk about, for example, competitiveness and innovation, and say that can butt up against, let's say, privacy is a fundamental right, arguing that stronger privacy rules may impede some of the innovation and competitiveness. How do you respond to sort of the balancing act sometimes that takes place, or even the argument that when it comes to a fundamental right, it's not about balancing some of these kinds of issues?
Well, the way I see it really is that we need to have both privacy and we have to have innovation, competitiveness, public interest, security, effectiveness, innovation, and so on. And there can be a tension. Absolutely. There can be a tension. They can appear to be at cross purposes. It can appear to be that if you improve the one, you're doing this at the expense of the other. That was true in my old world of pure human rights and equality and anti-discrimination, where there was the sense put forward that, well, if you protect human rights, you're going to reduce national security. You're going to reduce productivity in organizations. And so both in the human rights, pure human rights world and in the privacy world, my position is that we should reject this zero-sum result, and we should strive to have both. Is it easy to have both? No, it's not easy. It takes work. It takes work at the front end, and it takes consistent work. But it was President Kennedy, I believe, who said, we do those things not because they're easy, but because they're hard. I think that's absolutely true here. Privacy is a fundamental right. It means that it's something that's core to who we are as individuals. It's core to our dignity. It's core to so many other fundamental rights. And so we absolutely need to have that and to protect that and to strengthen that. At the same time, Canada needs to be competitive. We need to ensure that we have a robust economy. We need to ensure that we have public institutions that are able to deliver for Canadians on key areas of public interest, whether it's democracy, whether it's health, whether it's security, whether it's innovation. And so It's possible. It's possible we can do it. I think sometimes we are, and the Supreme Court has reminded us of this on occasion. We can be too quick sometimes to say, well, there is a conflict between those two things. There are sometimes conflicts, but I believe that we can avoid many, if not most, of the conflicts if we work hard at it, if we do privacy impact assessments, if we keep privacy top of mind. And so if we do this, we're going to be able to have both. And in the rare cases that we cannot, that is where privacy, being a fundamental right, will come into play, just as it does for human rights. And in those rare cases, privacy should prevail because of its predominant status.
Yeah, no, that's a perfect segue into drilling down a little more onto that issue of privacy as a fundamental right. That has been one of the issues that's been raised, I think, by a number of the opposition MPs and by certainly many academics and others, arguing that that needs to be better reflected in the legislation. What do you think that would mean in practice? How would you change the bill to better reflect privacy as a fundamental right?
Well, our recommendation to Parliament really focuses on two things: the preamble of the legislation and the purpose clause. And so we have, and this is something that is better about C-27. We highlight that in our recommendations, better than the former C-11, in the sense that there is a preamble that recognizes the importance of privacy, and it talks about privacy and it talks about international principles and so on. But the preamble, in my view, can and should be stronger. It can and should be more direct. It should not talk about privacy interests. It should talk about fundamental privacy rights. In the purpose clause of the bill, it should not only talk about privacy rights, it should talk about fundamental privacy rights. And what would that change? Well, what it would change is it would make explicit what the Supreme Court has already recognized, which is to say that legislation dealing with privacy is of a special status. It's of a quasi-constitutional nature, like human rights legislation. And what does that mean? Well, it means that, as I've stated earlier, in those cases where there is a conflict between a fundamental right and another interest or another objective that, while important, is not in the nature of a fundamental right, the fundamental right will prevail. And it's very important, and it frames the entire discussion such that privacy is not at the same level as economic success or even public interest consideration, which is not to say that these considerations are unimportant. I keep saying that we need to ensure that these objectives and these interests are also achieved. But again, it recognizes the paramount nature of privacy. And sometimes you may even have a conflict between two fundamental rights, and in such instances, courts will have to make some decisions as to which one would prevail. And we've had a recent example of federal court in a case called Kane, where the Supreme Court said both privacy and transparency, access, those are fundamental rights. But if there's a conflict between two, privacy is the one that ought to prevail. Again, because it is so fundamental to who we are as human beings. It's so fundamental to our dignity, to our ability to live freely. Some have described it as an insurance policy for democracy, or as a vector for freedom. And those things are all true. And so that's why it's important. That's why I keep talking about privacy as a fundamental right. It's not something that should be worrying businesses, in my view, because we can have economic success, innovation, while protecting privacy. But as human beings, we should all agree that privacy ought to be described and treated as a fundamental right.
Okay. Now, speaking of innovation and competitiveness, I did want to ask you about two of the recommendations in your document. First, you call for a strengthening of the framework for de-identified and anonymized information. How would you like to see that happen, or what would you like to see happen?
Well, some of the things, first of all, it's a good thing that the bill talks about de-identification and anonymization, and it highlights, it's a sign that the bill is modernizing and it is looking at today's reality. And there are many tools, privacy enhancing technologies that we can use so that data could be used for innovation and for public interest and so on, if it's treated in a way and it's modified in a way that it's not able to re-identify individuals. So the bill talks about de-identification, which is situations where there's no direct identification of someone, but there is still a risk that you can somehow re-identify individuals, and that those types of information, they remain governed under the law. And anonymized information, as you know, would be information where there's no possibility of identifying someone. And so that falls outside the scope of the Act. We're recommending a tightening of the definition for anonymization, really keeping the focus on this notion of the fact that you cannot re-identify the individual. There is a notion of generally accepted best practice that may well be form part of codes of practice and guidance and so on, but we recommended that the definition really focus on the essential element, which is no identification. And in terms of de-identification, we highlighted the importance of focusing on the risk of re-identification when dealing with this. The legislation talks about looking at sensitivity of the information, but it was lacking this notion of the risk of re-identification. We feel that's important, particularly because this is an area where technology moves so quickly, that this should be top of mind when dealing with this type of information, which will be treated differently under the Act as compared to personal information.
Yeah, no, speaking of, thanks for that. Speaking of technology moving quickly, AI is top of mind for a lot of people, and part of that, of course, is the move towards automated decision-making. You're calling for greater disclosure of automated decision-making. How would you envision that playing out?
Well, we've recommended that there be strong algorithmic transparency in the bill. The bill has some provision where there are some obligations proactively to provide information about the type of decision, the information that's used, and the purpose, and so on. And there's been this added element that the type of decision making has to be one that has a significant impact. So that's an added requirement, which we feel is appropriate for the broader proactive public-facing explanation. But with respect to another part of the bill, which gives individuals the right to request an explanation on demand, we recommend the removal of that condition, just so that the algorithmic transparency be broader, that this just gives more ability for Canadians to ask questions and to understand how are these decisions, recommendations being made that are affecting me. We also recommend that it be also the definition be amended to explicitly include profiling, so that there's no ambiguity. It removes the risk of this having to go to court and be litigated. So making it clear, just in the interest of providing more information to Canadians in an area that we see more and more use of these types of processes.
Yeah. Now speaking of Canadians asking for information, potentially launching complaints and various reviews, you emphasize as well in your recommendations as part of the privacy as an accelerator of trust, timeliness of decisions, streamline reviews. What are some of your concerns with the way the process functioning now, or how it might function if under C-27?
Well, it's always a tension, again, whether it's here in the privacy world, whether in my old world of human rights, it's always a tension between the processes, the speed, the time it takes for investigations to be completed, and then the quality and thoroughness of those investigations and the outcome at the end of the day. So we need to strike that right balance. We talked about the process under C-27, which would create a new step with the creation of the Privacy Tribunal, Personal Information and Data Protection Tribunal, that would be reviewing decisions, my decisions in terms of order making, and which would be receiving recommendations. And so we flag that in the sense that it's a new step in the court process. After that, you would have the Federal Court Trial Division. You would then have the Federal Court of Appeal, and with leave, you could go to the Supreme Court of Canada. So that additional step obviously would result in more time and more expenses to not so well to my office, but really what matters is to Canadians and to organizations. So our recommendation was that if we're going to have a tribunal as a next step, then we should remove one step from the process. And so we recommended that the appeals from the tribunal would go straight to the Federal Court of Appeal instead of the trial division. That way you would add a step, but you would reduce a step. And so that's that timing element. We indicated alternatively, you could do away with the tribunal and have the review go directly to the federal court. That's a possibility, but understanding the desire of the government at this stage, and now it was a desire that was also in C-11 to have that tribunal. We focused on what we could do to accelerate the timelines and to reduce the costs.
Okay, it's an interesting evolution in the thinking from your office, which previously some people were a bit surprised by the tribunal, now sort of trying to see how you can work with it. Let me quickly go through just a few other issues outside of C-27, just to get some of your quick thoughts.
Sure.
You talked about how long it's taken even for C-27 to come to committee. That pales by comparison, quite frankly, when we think about the Privacy Act and reform in terms of what the standards government holds itself to when it comes to privacy. You have any thoughts? This an issue that's been deviled all of your predecessors, quite literally. How can we jumpstart the process to reform the rules that government subjects itself to when it comes to privacy?
Well, I agree that it has to move much more quickly. Obviously, Privacy Act is even older than PIPEDA. It celebrated its 40th anniversary in July. So it needs to move forward. And I think the best thing we can do to move Privacy Act reform forward is to complete C-27 reviews, complete private sector Privacy Act review, especially if there's going to be the sense of a tribunal being created or different types of processes. I suspect Parliament may well want to have, and I would want as well, to have some interoperability between the private sector and the public sector regime. We want to make sure that the norms are similar, the processes are similar, obviously with the necessary distinctions, but we're seeing more and more public-private partnerships. And so having major gaps in terms of the privacy protections between the two is not helpful, and just creates these uncertainties and these challenges. And so the sooner it can happen, the better. And certainly I stand ready, as does my office, to support Parliament in getting this done.
Okay, so you've got private sector on the one side, public sector on the other, and then somehow you have political parties that somehow seem to fall through a gap altogether. You mentioned that you appeared before committee on C-47, the budget implementation bill. I had Colin Bennett on my podcast recently talking about the inclusion of what I think most regard as pretty weak rules for political parties. Can you share some of the thoughts that you shared with the committee, both on the substance of what you find in C-47 and perhaps also the decision to include privacy in this kind of omnibus way within a budget bill?
Well, I shared my view with the Senate committee, and there were really two key elements to that. My view that the political parties ought to be governed by privacy rules that meet international standards. Right now, the existing rule in the Elections Act require the political parties to publish their policies, and so their transparency requirements, but doesn't go much further than that. So it ought to be, in my view, that the similar principles as ones found in PIPEDA, in Privacy Act, really to highlight that. Now, again, there may well be some necessary modifications to take into consideration the reality of political party. It again goes to my second point, where we should have privacy, but we should also allow public interests and innovation, and in the case of political party, ultimately democracy. That's fundamental. So we can't have rules that are going to be preventing political parties from operating. But again, it's not a zero-sum game. So we need to have these types of rules. And the other issue was that under C-47, political parties are required to follow the rules they set for themselves, but there's no third-party independent decision maker to review that in situations of complaint. So really what it looks like is you would go to the party's ombudsperson. So I recommend that you need good norms, and you also need a good decision-making process with a neutral third party. So I hope to see that, and that's really in the hands of Parliament at this stage.
Yeah, it is. I think it's a lot of people have been concerned. Two last issues. You highlighted one, and I recognize there may be some limits on what you can say. One involves the case involving Facebook and Cambridge Analytica. That decision contains some pretty strong words about the evidence that was mounted by your office. You've now appealed. Can you describe at all your reaction to the decision, and how far are you prepared to take the case?
Well, certainly, we launched an appeal. The decision was not the decision we were hoping for, obviously, and we feel that there are some outstanding questions that will benefit from clarification from the Court of Appeal. It's an important case. It raises important questions. And that is frankly why we have an appeal process and the ability to go to higher courts in appropriate cases. And so we're doing that, and we'll look forward to making our submissions in the appeal court and to receiving the clarification. And so we'll see what unfolds in this process.
Okay, fair enough. Finally, AI has clearly been top of mind for months now. Your office has launched an investigation into ChatGPT. I've got lots of AI questions, but just to limit them, I guess, what sparked the investigation? And I think more broadly, how closely you've been tracking AI developments, including the C-27 AI provisions, where there are quite a number of people that would have preferred to see the AI portion of that bill separated or excluded from the privacy portions of the bill.
Right. Well, it's interesting, and again, we'll see what Parliament does with C-27 and the AI portion. I think that the government, the bill really deals with AI from the privacy standpoint in the proposed CPPA. So the algorithmic transparency that we were talking about, we've recommended for there to be some mandatory privacy impact assessment in situations that have higher impact, and that would certainly apply to much of AI. So that would strengthen that. So the privacy side of AI would continue to be under my responsibility in terms of the complaint process and the guidance and so on. But the ADA bill would deal with the outputs of AI processes, high impact AI processes to prevent harms and to prevent biases, including human rights type biases that would otherwise or could alternatively be dealt with by the human rights process. And so what's important from our standpoint, and it's another of our recommendation, is that whatever the process, that there be collaboration and good consultation between those two sides, because it's not always a clear cut between the outputs and the input. There are often impacts. The input will have an impact, the privacy aspects will have an impact, and vice versa. So it will be important that we continue to be involved in all of that. It's one of my priorities and the office's priorities that we keep up with and hopefully stay ahead of fast moving technology. Another, speaking of hard things to do, that's certainly one of them. But we need to do it. And so we've been making key recommendations in terms of AI in my office. Before I was here, we've had some recommendations in 2020, and in terms of the complaint, again, we look at complaints as they come. This situation with ChatGPT, we received the complaint, and certainly was something that raised important questions in terms of consent and use of personal information in terms of fueling these AI systems. And so it's something that we're looking forward to see progress. And I think that there's been lots of calls in academics and internationally about guidance and about regulation of this fast moving technology. So we will certainly be playing our role in that from the privacy standpoint.
Okay, definitely a full plate. And so I appreciate you taking the time to talk a bit about your perspective, and certainly look forward to seeing you at committee and seeing, many others who've been really, I think, chomping at the bit to move forward with C-27. So thanks for your work in this area, and thanks for the time today.
Thank you so much, Professor Geis, and I hope we'll cross paths in committees as well in the next few weeks or months.
Definitely a possibility. Thank you. That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes at pobox.com. Follow the podcast on Twitter at lawbytespod or Michael Geist at mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.